Hey, it's Brian of BenGlassLaw. I'm here with Jason Krumbein of Krumbein Consumer Legal Services out of Richmond. Jason was up in Alexandria General District Court today winning a dismissal for one of his clients, and he stopped by the studio to talk to us about his consumer finance practice. Welcome, Jason.
Thank you very much. I am glad to be here with you today. Glad to be talking to your viewers. Let me know what I can do that I can help you and your clients.
Well, why don't we start by talking a little bit about your practice? What is it that you do?
I litigate credit reporting errors, and I litigate debt collection related issues. There are two pieces to the debt collection. One is the defense of a lawsuit where someone is suing to collect the money, and the other is going after somebody who is engaging in, for lack of a better term, bad actions collecting a debt. Abusive, harassive, false and misleading kinds of stuff. And the laws that are related are the Fair Credit Reporting Act. It's a federal statute at Title 15 of the U.S. Code, Section 1681, and the Fair Debt Collection Practices Act at 15 U.S.C. 1692. And then debt collection, of course, is an amalgamation of contracts and torts and evidence and rules of procedure and all sorts of weird stuff like that.
And where in the process would people find you? Do you represent anybody that's being sued for any debt, or are there certain classes of people that are better served by having you in the case than others?
Well, there are some things for which it is just, for the most part, a bad idea to hire somebody like me who specializes in consumer issues. If you're, for example, a doctor being sued on a medical malpractice, you really need a medical malpractice defense lawyer.
Sure.
If you're being sued for a car accident, you need a car accident defense lawyer. But if you're being sued on something that would be a consumer finance kind of thing, an old credit card or a student loan or a repossessed car or something like that, those are the kinds of things that are my specialty.
And so in my world, doing plaintiff's personal injury work, a lot of times I have clients who either don't have health insurance or can't manage the copays as the case is going on. And so they might get sent to collections during the course of our injury case before they get a recovery from the liability carrier for some of their medical costs.
That is perfect for the kinds of stuff that I do. Because here's the thing. For a personal injury case, one of the key elements is damages. No damages, no case. But the damages tend to revolve around, particularly in a car accident case, medical damages, because from the accident you were carted away from the scene in an ambulance. The ambulance certainly would like to get paid, and you went to the emergency room. The emergency room needs to get paid. The emergency room doctors need to get paid. The follow-up treating physicians need to be paid. There may be surgical bills. There may be all sorts of other things that happen in the wake of a car accident. All of those medical bills are bills that sometimes your insurance pays quickly, sometimes the insurance pays not so quickly. And I can help with some of that. It's not as easy as I certainly do make it sound. But there are ways that we can do things to either delay payment so that it gets paid out of the proceeds,
right.
Or sometimes I've even been able to get a debt collector, or more than one, to decide that maybe it's not a good idea for this particular consumer to pay this bill at all. And that, of course, increases the recovery for the consumer because they no longer have to pay the medical bill in addition to whatever else that they have to pay.
And I'll come back to that part in a second, but I want to ask you about ways to delay collections proceedings during the course of a case. Because the scenario for my clients typically is something like, I went to a hospital, I was treated at the hospital, and I don't have health insurance. And then the hospital will sell that bill to a debt collector, and all of a sudden they're getting notices not from Inova or Centera, but from somebody who they don't even recognize. And sometimes it even gets sold to a second debt collector, right?
Yep.
And so how do you, as a consumer, manage those letters when they're coming in and prevent yourself from being sued in the first place? And how do you reach out and say to a debt collector something like, listen, man, I've got an auto accident claim that's going to pay at some point, but I don't have the funds to pay you $10,000 today?
Well, there are two questions that you really asked. One is, how do you prevent getting sued? And the answer is, you can't. You know as well as I do that anyone in America can sue anyone for anything. The question is, can they win? And that's a more difficult question that honestly is very fact-specific, because when the hospital is collecting their own bill, that makes it a little bit more difficult for someone like me to defend the collection lawsuit and perhaps even find a way to prevent paying that at all. There is also the circumstance of the hospital has actually sold the bill, and the named plaintiff is no longer Dr. Jones, who worked on your broken leg, but a debt buyer who says, I bought the debt from Dr. Jones. I, granted, only paid him 10 cents on the dollar for this bill, but you now owe me. Well, that's much easier, because in order to get that judgment, that debt collector still has to go through all the effort to prove that the bill is reasonable, that it's necessary, that the bill is actually owed to Dr. Jones, that Dr. Jones sold it to that debt collector, all of which has multiple layers and problems of evidence and procedure in getting that information into court. Now, with a personal injury claim, that is not quite so difficult when you, as a personal injury lawyer, are trying to get that information into court, because you can take that bill from the doctor's office, and maybe it takes an affidavit or something like that, and you present that, and that is evidence that there was a bill, that it's reasonable, and then the defense lawyer has to make a decision about whether they want to depose the doctor over whether that was reasonable or necessary or whatever they're going to do.
Well, in our cases, it's easy. The statute says if it's a bill that a plaintiff or a patient received in the mail, it's presumed to be reasonable, and it's presumed to be authentic on its face. We have other issues in terms of, is it related to the crash, or is it something else? But getting that bill into evidence is pretty easy for us. But you're telling me it's harder for a debt collector.
For a debt buyer. And it's very important to identify the difference between a debt buyer and just a plain old debt collector, because a plain old debt collector includes the definitions of lawyers who are collecting bills on behalf of somebody else, and it includes just somebody who's calling. There are a number of collection agencies that are no longer in business. They are classified as a debt collector. They would call and they'd say, you owe Dr. Jones, and we're collecting for Dr. Jones, please pay us. They're a debt collector. A lawyer also qualifies as a debt collector. And the Supreme Court has entered into some very good rulings on that. Actually, those rulings are relatively old, saying that a lawyer collecting a debt is a debt collector. But there's also the secondary category of a debt buyer. So it's easier for me to talk in terms of credit cards, because that's sort of the core of what I spend a lot of time on. Say you owe Capital One. Capital One sells the debt to First American Debt Recovery. First American Debt Recovery hires a lawyer to recover that money, and they sue. Now, the named plaintiff is First American Debt Recovery, assignee of Capital One, versus Joe Consumer. First American Debt Recovery has serious issues of evidence and procedure in getting that into court. It's, for lack of a better term, there's almost nothing that they can do that isn't hearsay. They end up testifying mostly what he said. Well, that's the definition of hearsay.
And the lawyers that handle those cases are going to walk into court in Fairfax or Alexandria or Prince William with 50 to 75 cases at a time.
Or more.
All of whom have different witnesses that you would need to call if you were pursuing it.
Absolutely.
And so it seems to me that if you show up by yourself, or especially if you show up with a lawyer and you contest some of those evidentiary things, they're going to have a very, very hard time proving their case and collecting against you.
Exactly. It's all about you just simply saying, hold on, who are you? And it's not a remarkably complex, detailed investigation. Obviously, it's much harder for somebody to do it themselves because there are questions that a plaintiff's lawyer, a plaintiff's collections lawyer, can ask.
At least I know from law school some of the bases of evidence, right?
Sure.
Even if I have never done debt collection work in my life.
Exactly. But with a with a lawyer protecting a consumer, just simply standing there in between and saying, hold on, I don't think you're allowed to ask that question. You can ask all sorts of stuff and stop a debt collector from collecting. Again, the easy ones for me to identify are credit cards, but it also works with medical bills that have been sold. I don't see a whole lot of medical bills being sold. I see a lot of them where they have been sent to a debt collection lawyer who then files a lawsuit, and then if they decide they wish to proceed with this lawsuit, they decide whether they wish to bring in a witness from Centera or Innova or wherever. So,
and the judge is never going to stand up 99 times out of 100 is not going to stand up for a defendant in a debt collection case and say, you can't ask that plaintiff's lawyer, right?
I've never seen a judge stand up and defend a consumer. That's not their job.
That's not their job. Yeah.
That's not their job. So because that's not their job, they really are not supposed to do that. They're supposed to help people who are representing themselves, but there's a limit to what they can do.
You can see it if you sit long enough in a courtroom because they will say, listen, I think you might want to have a lawyer the first time you're in court. They'll say, next time you come back, if you're going to contest this, you probably want a lawyer.
Yeah.
And then I can see some of the judges struggling with, I have to apply the rules the exact same way to the plaintiff and the defendant, even though the defendant doesn't have a lawyer. And they just say, too bad. If you don't know the objections, if you don't ask me to call the balls and strikes, I can't call them.
Exactly. Yeah. That is exactly what happens. And that's why it's so important to go see a lawyer. People would not attempt to treat a medical issue on their own. They'd go see a doctor.
Oh, you'd be surprised.
Yeah. And the results are equally disastrous.
That's right.
Equally disastrous.
And you've had cases where you've defended somebody whose credit card debt had been sold to a debt buyer and either chase that debt away or how do those usually resolve? About
99% of them, the debt buyer just sort of goes away.
Yeah.
It's not 100% of the time. Sometimes they really do fight me, but there are some of them where they have discovered that I put up enough of a fight that they just decided that I'm the cost of doing business. I file a notice of appearance, and they've already disappeared.
And if I'm one of those lawyers, I've got 50 or 75 cases on my plate, I can worry about the other 49 to 74.
Absolutely.
And not deal with you. And my client has bought that debt for 10 cents on the dollar.
If that much.
Yeah.
Often it's much less. I've seen it as low as 2 cents on the dollar.
And so really the goal of these debt buyers is to get a default judgment.
Absolutely.
And then execute on garnish your wages or execute on your house or.
Absolutely. And they would really love to garnish wages or take a bank account. They don't really, really want a bank account because people who have their bank account attached end up going to see a bankruptcy lawyer, then they get no money. They don't really want to go after houses because it's a lot of work. It's not that they can't. It's they can be
low-hanging fruit.
They can be lazy and wait for the money.
Sure.
With a lien on a house, they just sit there and wait, and eventually somebody will either sell the house or refinance the house or something like that, and they just sit there and wait, and all of a sudden they get paid, and they get a call. Hey, we'd like to give you some money. Glad to take your money.
So let's talk about the other side of your practice. Okay. If you're not defending a case, you bring cases also.
Yes.
What kind of cases?
two kinds of cases. I sue debt collectors. Those are relatively simple, straightforward. A debt collector is engaging in behavior that is abusive or harassive, false and misleading, or generally unfair. And the other stuff is the credit reporting violations. That's where somebody has reported on someone's credit report information that is not true, complete, and accurate. And that one's a little bit more complex to go through the pieces of because there's so many additional pieces.
And the debt collection cases, that's the kind of cases where they're calling you 7 times a day up until 11 o'clock at night and saying, pay me, pay me, pay me. And they're calling your wife and making threats and things like that, right?
Absolutely.
What kind of things have you seen?
I have seen stuff that is absolutely amazing. Two of my favorite cases on debt collection abuse that I've seen over the last, I guess I've been doing this almost 20 years. I had one client out in the Western District of Virginia. The debt collector called, left a voicemail. This is the fun part. They left a voicemail. Sort of hard to deny that you did it.
It's like don't put it in writing, right?
Yeah, exactly. So the debt collector calls, leaves a voicemail, and says that they are preparing to take a civil deposition prior to a criminal indictment for failure. Yeah, I can see you're laughing already. Failure to pay a credit card, and you're going to be transported on Thursday.
Yeah. Oh, I'm laughing, but I bet your client wasn't.
Client was very upset.
Yeah.
And obviously, this is honestly, from my perspective, this is a low-hanging fruit.
Yeah.
All I got to do is find the defendant,
Right.
and I'm getting real money.
Well, so tell me what that looks like. So what can you do for people who are getting those kinds of phone calls for fair debt under the Fair Debt Act?
For the stuff like that, there are two kinds of things that we can do. For the debt collectors that are on the edge, but they're not really bad, they're not calling and saying you're going to go to jail. You can write them a letter and say, I refuse to pay. You can write them a letter and say, I've hired a lawyer. Here's my lawyer's contact information. Don't contact me. You can see what they can do for some sort of dealing with the actual debt. And the most important thing is you can ask for information about this debt, because some of these debts that they're collecting are actually really old. I have seen debt collectors collecting on credit cards as old as 10, 15, 20 years old. I had a client who had a private student loan that he had taken out before I was born. I was born in the late 1960s. This student loan was ancient. Supposedly, he had stopped paying in the, I want to say, the mid-'70s, might have been the late '80s. I was a small child.
Right. And he didn't have the canceled checks to prove that he had been paying?
It doesn't matter anymore. That debt is so far beyond the statute of limitations that I don't even know where the statute of limitations expired.
Right.
So ask some questions about the debt. What is this? How old is this? When was the last payment made? When was the last time that the debt was in fact current? Because that's when the statute of limitations starts running. So most people think that the statute starts when you make your last payment. That's not necessarily true. It occurs when default occurs, and I'm going to use default in air quotes because you have to look at the terms to determine when default occurs.
Okay.
It can be anywhere from 30 days after you first fail to make a payment to 6 months after you first fail to make a payment and don't call in or don't do this or do that, which is some of the student loan stuff. So there's all sorts of things. And the statute of limitations varies extensively to some extent depending on what kind of thing it is. So, for example, a federal student loan never expires, even if you took out that loan before my grandparents were born.
Right. Federal government always going to get their money back.
Feds always get their money. But private student loans, state student loans, credit cards, medical bills, all these things have statutes of limitations. Car accidents, medical malpractice, all this stuff has a statute of limitations. If you wait 20 years to file your lawsuit, you lose. Well, it's the same thing with any of the other things, credit cards, medical bills, defaulted car loans, defaulted mortgages, anything like that. Those have time limits. So when they miss that time period, there are, obviously you can tell the debt collector, you can't collect this.
Right.
I'm not paying you because the statute of limitations has long expired, and I don't have to pay you. And there's not much that the debt collector can do. Now, here's where it gets to be fun. If the debt collector sues or threatens to sue, that is a violation of the debt collection rules.
This is after you've told them.
After you've told,
It's expired and I'm not going to pay you.
Even if they have not been told that this is expired. Let's say let's take the example of a credit card because that's the easy one. Statute of limitations is somewhere between 3 and 5 years. Let's say they are calling at 7 years and say, we're going to sue if you don't pay. This is a terribly scary moment. I mean, honestly, it's scary even to hear that, and I'm a lawyer.
Right.
So when they say, I'm going to sue and on this debt, the fact that it's 7 years old automatically means we have a little bit of an issue. Suing or threatening to sue violates the Fair Debt Collection Practices Act. Some really good case law, it's out of almost every circuit at this point, that says suing or threatening to sue on a time-barred debt violates the Fair Debt Collection Practices Act. Well, now, that one's going to be relatively rare in the context of a personal injury case, a car accident, a medical malpractice, something like that, because the statute of limitations on that is shorter than the bill on a medical bill or a credit card or anything else. But you sometimes do see years later the debt collector comes back because somebody forgot to file whatever.
There's new management and they're looking through all the books.
Yeah, that's exactly right. Yeah. And then, of course, the consumer comes back to you and says, why didn't this get paid? And, of course, your response is they didn't tell us about this bill. There are things that they can do where they can file a notice that they're supposed to get paid. And that's something that's your area of practice. But if they don't ever tell you about this bill, you'll never pay them.
Right. And so what can you do for people that are getting those harassing phone calls? How do you make it stop?
Step one is the consumer should tell them to stop. Step two is the consumer should write a letter and say, stop calling me. And they can use literally those words. And it's actually relatively good to use those exact words, stop calling me. And then, of course, finally, they can hire a lawyer. Now, the hard ones are the ones that are playing hardball. Many times I find that the ones that are truly playing hardball, you're going to go to jail, I hope you look good in orange. I've got that one too. I see you're laughing. That's another one.
That's outrageous.
It is. I had a client who was a U.S. citizen who was a Spanish-speaking American citizen. She had been born here. I want to say her parents had been born here. There's no question she's a U.S. citizen. The debt collector calls, leaves a message in Spanish saying, you're going to be deported. I'm going, to where? And then, I hope you look good in orange. I'm going, why would my client be wearing orange? Once we found out who the debt collector was, that one paid off relatively well.
So talk to me about that, right? I mean, I envision that many people who have outstanding debts don't have a lot of liquidity to hire a lawyer for a case like this. So how does somebody avail themselves of your services?
That's the great thing about this statute. People don't care how much I charge because I'm not really charging them. These cases are taken almost exclusively on a contingency fee basis. That means that
if you don't win,
I don't get paid. I get paid on the back end. I get paid out of the settlement or the judgment. The statute in question, the Fair Debt Collection Practices Act, calls for actual damages plus statutory damages. The Supreme Court has clarified and made it so that if you don't have any actual damages, you can't get statutory damages either. Plus, here's the part where I get to have fun, plus attorney's fees and costs.
Right.
So obviously we know why I'm in the case, because plus attorney fees and costs.
Well, and but if it weren't for that last part of the damages, there wouldn't be a lot of attorneys that would take these cases.
Absolutely, you are correct.
So, can you talk a little bit about what an actual damages are in a case where somebody's calling you and saying you owe me money that you don't actually owe?
Generally, I am a big fan of emotional distress damages. And it's different from a case for intentional infliction of emotional distress or something like that, because I just have to show that there was an effect and that there was a third party who saw that effect. So, sleepless nights, crying, not making dinner, snapping at the family, yelling and screaming. I had a client who quite literally made only mashed potatoes or spaghetti for 2 weeks based upon the offensive actions of the debt collector. She had intermittently smoked before, but now she was chain smoking and drinking massive volumes of Turkish coffee, which is very good, but not so good in that quantity.
Not in high dosages, sure.
And literally banging her head on the wall, screaming, "Why are they doing this to me?" Well, obviously, this was a case that had some real good emotional distress damages. Her parents saw it, her child saw it, other people saw it. The fact that she didn't leave the house for 2 weeks, people noticed. All this combined into a great case for emotional distress damages.
Who determines what those are? Are these heard by a jury, or does just the judge hear these cases?
I'm a big fan of let it go to a jury, because juries are unpredictable. This is the kind of thing where a jury could decide that it's worth $1,000, or a jury could decide that it's worth $100,000.
Sure.
Or if you live in Washington or Oregon or someplace like that, it's worth $100 million.
Right.
You know, we don't live in a place like that.
Right.
I'm kind of glad.
Right.
But it's the kind of place where, this is the kind of place where that kind of emotional distress damages could be worth real life-changing kinds of volumes of money. There's a fabulous case out of the, I want to say it's the Ninth Circuit, in which the debt collector was suing on a time-barred debt. I love these cases. You can tell, can't you? At the trial in the state court, the debt collector acknowledged that no payment had been received in, I want to say, 7 years. The only quote-unquote credit had been a refund of improperly forwarded filing fees that had been sent to a court. And that's why they decided that it was not time-barred, except that's not what the law is.
Right.
Now,
I have no idea. I'm just saying right because you're telling me that that's not what the law is. Yeah.
So in I want to say it was either Idaho or Washington or someplace like that, wherever that case was, the jury came back and decided that based upon how upset this man was, he was a disabled American veteran who had been had brain trauma and all sorts of things, and he's going, I don't think I owe this. This is just way old. When the jury finally got to hear this and heard how the debt collectors had said, we don't care, they awarded over $100,000 in actual damages.
Wow.
Now, that's Idaho or Washington or wherever, but that kind of thing could happen here.
Sure. And in addition to that, you would have statutory damages.
In addition to that, you'd have statutory damages. And in addition to that, you have, why I'm involved in the case, the attorney's fees and costs. So what I charge, nobody cares what I charge. At least my clients don't care what I charge. Still, it's the people on the other side. They get very upset at the amounts that I charge.
Right. And you handle cases all over Virginia?
All over, from Virginia Beach all the way out to Lee County, all the way at the tip of the boot, from Alexandria and Northern Virginia all the way down to the southern edge borders.
So how are you doing that from Richmond? You don't have clients driving in from Roanoke and from Newport News to meet with you?
Most of the time, the initial consultation is over the phone. I arrange for meetings with clients. If they're willing to come to Richmond, obviously that makes things a little bit easier. But if they're not, then I can meet them typically. If they're in like Lee County or someplace like that, all the way at I'll arrange to meet them halfway in Harrisonburg or Charlottesville or someplace like that. And we'll find either a lawyer who I know who's willing to loan me an office, or I've met people at Panera or other, someplace like that. We sit in a quiet corner, we talk about the case. But typically, that's the point where I'm starting to say, okay, let's talk about getting real money, not just a couple of dollars.
Right.
A lot of these cases resolve for a couple of dollars, and the debt collector goes away. That's what most people really want.
Because the easy cases should resolve for a couple
exactly.
of dollars. Right.
And most of the time, that's what my client really wants, is the debt collector to go away and pay my attorney's fees and put something in their pocket.
Right.
Oh, okay, fine.
Right.
So those kind of cases, that's relatively easy. When we start talking about cases where you have staying up all night and chain smoking and banging heads on walls, we're talking real money. That's the time where I'm starting to say, okay, we need to have a couple of meetings live and in person.
And you need to go and evaluate that client.
I need to go and evaluate that client, look the client in the eye, decide how much I think they're a believable client, decide how much of a cooperative client this is.
Decide whether it's somebody you actually want to work with for the next 6 months, 18 months, right?
Exactly. And some of these cases can last for a good period of time. The great thing is that being here in Virginia, we have what's called the Rocket Docket.
Yeah.
And for the viewers who are unaware, the Rocket Docket is one of the fastest courts in the nation. Average time for cases in the Eastern District of Virginia, which is from a little bit west of 95 through Virginia Beach and the Eastern Shore, average time for a case to go to trial is 8.6 months, which is really fast. That we're talking about a federal trial. Average time is 8.6 months. In most other jurisdictions, at 8.6 months, they haven't had a case management meeting. And that is just mind-boggling to me because I've been practicing here.
And from your perspective, that doesn't give the debt buyer or the collection agency an awful lot of time to get all their paperwork together.
Absolutely. Gives them almost no time. And actually, it's kind of interesting. I've had cases where the case proceeded in federal court faster than I could have done it in a small claims court, in a general district court. I had a case that I filed in July. They filed their answer in August. We had a case management meeting in front of the judge like the first week of September, and the judge wanted to set the trial for the first week of November. I've been in lots of general district courts going...
I've never had that happen.
Yeah. Yeah, it doesn't happen. Even in general district court, it doesn't happen that fast.
And so what about Fair Credit Act?
Fair credit's a little bit more complicated. Let's talk. This is actually where I start to have to get into the nuts and bolts of the law. Okay. There are some important elements to a fair credit claim. Number one is that the information must be false or misleading on the credit report.
And so this is if I go to apply for a mortgage and it says that I have debt somewhere or I have a criminal conviction, what other kinds of things might be false on my credit report?
Those are the two most common that I see. Very rarely I see other things. There are a bunch of companies that do background checks based upon driving record, particularly for truck driving schools, and they look to see, and again, you have the same kind of stuff.
New hires, right? You might outsource some of your background work to somebody else.
Exactly. But you start with there's false information on your on your file, whether it's a criminal history or a true credit history or whatever. The background about you is inaccurate or false or misleading. Number two is that they had some basis to understand that this information was incorrect. That's a not great case right there, but it's possible. And then it is made a whole lot better and almost a slam dunk when you ask them to correct it. And the important piece is not necessarily, this is the key piece, not necessarily to communicate with the source of the information, but to communicate with the credit bureau.
Okay.
And I know that sounds really
So
backwards.
tell me what that means.
Right. That means the easiest way to describe this is to use specific examples. Let's say you are looking at your Equifax credit report and you see that Capital One has reported that you owe a defaulted debt. Most people would reasonably communicate with Capital One and say, hey, I don't owe you this money. I never had this account. I paid this account, whatever. Mm-hmm. But that's not the way the law works, because it was written by 535 people living in Washington,
Sure.
D.C., not by any of the people who live in America. So the thing that the law requires is not that you communicate with Capital One, but that you communicate with Equifax.
Okay.
Once you communicate with Equifax, Equifax has an independent duty to do their own investigation to look and see whether or not your claims that you don't owe this money are correct. If you say, I paid this bill, they're supposed to look into it and see whether or not the bill was actually paid. If you say, this is not my bill, they're supposed to look into it and see and maybe compare signatures or something like that. That's not to say that it's an absolute, but they've got to make some reasonable investigation.
Do they have to do something beyond calling Capital One and saying, does
Yes.
he actually owe this money?
That is exactly the issue. They have a duty under federal law to do their own investigation into figuring out whether or not this money is owed.
How often do they do that?
I have a job because they don't.
Right.
And that may give you an idea. I'm not going to say that they never do it, but I am going to say that it's rare enough that I have a job litigating credit reporting errors. So when they do that, they do the Equifax investigation. Equifax now has a duty to look at it and figure out what they're doing. Now, also, Capital One has a duty because the credit bureau, Equifax in this case, has a duty to send that information all about why you claim that you don't owe this debt or don't owe this amount or whatever to Capital One. Capital One has a duty to do their own independent investigation. And therein lies the problem again. I have a job because all too often that is not done as well as they should have.
I mean, it seems to me that both you and I have jobs because big, dumb, slow companies don't treat people fairly.
I'd say that's probably the most true statement I've heard in a very long time.
Yeah, I mean, in my world, if at least from an economic perspective, if insurance companies, auto insurance companies mostly, would offer prospective plaintiffs 75% of the value of the case, they would come out economically ahead of hiring a personal injury lawyer.
Yes.
Right? But they don't do it.
No, they don't.
So, I mean, if there were, if they figured that out, they would wipe this industry off the map.
Yeah. There are lots of industries that could be wiped off the map by just simply people on the other side doing the right thing and figuring out something reasonable. Now, that I do want to say there are circumstances where people in your profession, people in my profession, would not be out of a job. Because there are always going to be cases where it's questionable.
It's always legitimate fights, right?
Who really caused that accident? Does this person really owe this money? Those cases are always going to come up. They will always be there. You'll always have a job for that kind of stuff. Now, all too often, you are also getting cases where it is clear-cut. My client was rear-ended. You need to pay up.
Right.
This is clearly not my client's debt. You need to pay up. But they don't. And that's why you and I have jobs.
I settled a case 3 weeks ago for $325,000 where there was no offer before we filed a lawsuit.
Right.
And we didn't really get that deep into discovery.
Right.
You know, a lawyer got involved, and all of a sudden it went from a $0 case. It was a case where two people claimed they had a green light. One of them happened to get a ticket, not my client. And the insurance company
that makes it a lot easier.
Said, oh, our guy, even though he got the ticket and even though he paid the ticket, we don't think he ran the light. I said, great. So
let's let a jury find out.
Well, and we didn't have to because they resolved it for all of the insurance, all of the available insurance.
Right.
Right. But they could have done it for something shy of $325,000 if they just treated this lady fairly in the beginning.
Exactly. Right. And that's exactly the situation that I see all too often. I have a client that I am working on filing a lawsuit right now. He has a not uncommon name. It's not It's not John Smith.
John Smith. Yeah.
But it's still a relatively common name, and somebody with the same first name and last name, different middle initial, different social, has been a bad boy and not paid his bills, and not paid lots of his bills. Now, my client pays his bills. I've looked at the bills that my client really does owe, and he pays his bills. He pays his rent. He'd love to buy a house, but he can't because the other guy with the same name has not paid his bills. My client has never filed for bankruptcy. The other guy has. My client has continued to pay his bills. The other guy, even though he filed bankruptcy, still isn't paying his bills. This guy has trashed credit. But it's not my client.
Right. And it's not your job, I imagine, to prove that it's not your client. In that kind of a case, isn't the burden on the credit bureau to prove that it is, and that if it stays on his report?
Therein lies a difficulty, because the statute starts with false information. So the burden is actually on us to make at least some offer of proof that the information is not, in fact, true. That means...
With the different middle initial and different social, that's probably not terribly hard.
That's exactly right. So all I got to do is get into that file and say, talk to the representative from Equifax or TransUnion or Experian and say, so tell me about who really owes this money. Is it John A. Doe or is it John B. Doe? And they'll say, well, it's John B. Doe. And I'll go, well, that's funny. My client's John A. Doe. And at that point, the case is largely over.
Right. Should be.
Right. You would think so. And that is where we go from there. And that's the kind of stuff that is lots of fun. But it's not just financial stuff. And the financial stuff comes in two varieties. I'll come back to the financial stuff because, of course, there is also criminal history. I have a client right now. He was applying for an apartment, and many apartments have a requirement that you have a clean criminal record for such and such a period of time. My client has never been to Connecticut. Somebody with the same first and last name, again, who lives in Connecticut, has been a guest of the state of Connecticut. And there's a felony. Now, obviously, it's not my client because my client's never been to Connecticut, much less been arrested or convicted or charged with anything in Connecticut. So my client can't possibly be that same person. Well, that's false information. All I've got to do is get into the file at the background check company and say, so, who's this? And their response is going to be, not a clue. Because that's absolutely what's going to happen. They're going to say, I don't know who this is. This compared to your client, I have no idea who this is.
And in these fair credit cases, the actual damages that we talked about a little bit earlier become a little bit more interesting, right? Because you might get denied a mortgage, you might get a mortgage at a higher rate, or you might not be able to find employment, right? You might get all the way through the interview process and then find out that you didn't get the job because somebody in Connecticut with your same name had been in the penitentiary.
Exactly. It's exactly correct. And that's exactly what happened to my client. He lost an apartment. We also suspect that there were some job losses, but we haven't gotten all the pieces to put that together yet. But imagine the economic impact of not being homeless because you are a felon,
Right.
not being able to get a job because you are a felon, all of which is completely false.
And in the job piece, does an employer have to tell you that we didn't hire you because of your felony conviction?
They are required to tell you that they obtained information from a specific source and that that source is the reason why they turned you down. Not everybody does that. They don't always do that in providing correct forms. That may create an additional basis to sue. But I tend to be a little bit more careful about those. And the reason why I'm careful about those is because I'd like to have my client be able to get employed by somebody. And that's the kind of thing where you might end up with some sort of a black mark on your. So I'm a bit careful on those.
Well, and those are, that goes back to the client evaluation, right?
Right.
Somebody comes in and says, I didn't get a job because they said something's on my report. And that might be the case, but it might be that it was something totally different on the report. That is a legitimate reason to not give somebody a job.
Exactly. Or apartment or mortgage or whatever. And those people do walk in my door. I have a client right now that I'm walking through the pieces of analyzing. He was convicted of distributing a controlled substance, I want to say 30 years ago in Pennsylvania. Theoretically, under the fair housing statutes, that is a basis to deny housing. However, if it's more than a certain period of time, it has to be an individualized assessment. This is where I get into, I don't understand all the pieces. I have to contact one of my friends who specializes in housing law, fair housing, things like that. And we start looking through, did they do what they were supposed to do? Did they say this? Did they say that? Now, here's the question. Did the file of whoever did the background check legitimately say that it was conviction for controlled substance, that it was Pennsylvania, that it was 27 years ago, or have they made it look like it was really 9 years ago?
Right. Or impossible to tell how long ago it was.
Or impossible to tell. And it's really hard in that circumstance to just, what I have is your criminal history means that you are ineligible for an apartment at this complex. And that makes things much more difficult. And I will say that particularly among minority communities, this is a particularly difficult, thorny problem because the police look at minority communities a lot more. So people of minority communities get arrested more.
Sure.
They get charged with more. They get convicted of more. And sometimes they deserve it, but a lot of times it's questionable. And because they are in a minority community with a limited source of funds, they don't have the money to hire a high-priced, law firm criminal defense attorney who charges $1,000 an hour. These people don't have $1,000 that they can throw at a lawyer for the entire case.
So they might end up with a public defender who's overworked and
the public defender says, look, you're going to be convicted anyway, so let's just make a deal.
So it doesn't matter where in this tier of crimes you are convicted. If we can work out what's often important to the client, which is a fine or the jail time, I don't care if it's a level 1, 2, or 3 crime, right? That's interesting.
And a perfect example of that, I have a good friend who was charged with DUI, didn't have the money to hire their own lawyer, so they went to a public defender. And if there had been a private attorney, they would have gotten into all the issues of the emotional upset. She was going through a divorce and this, that, and the other thing, and whatever. And it's possible that the reason why she was driving so questionably was that she was so emotionally distraught. But the public defender looked at her and said, look, the officer said that he smelled alcohol, and you're going to lose your license anyway. Let's see if we can make a deal for no jail time and they'll drop the refusal,
Right.
which really shouldn't have been a refusal, and you go on your way.
Mm-hmm.
Well, she had no choice, because the choice at that point would have been 6 months or a year in jail with no license, and when she gets out, this is a bad outcome.
But she doesn't understand all the downstream consequences.
Exactly. And in her case, it's just a DUI. It's not so horrible. But imagine that you are living in a community where there is a particularly high prevalence of drug crime, and somebody runs by and throws something at you, and within seconds a police officer turns around the corner, sees you holding whatever was just thrown at you, tackles you. You went down on possession of narcotics and possibly attempted distribution or something like that. Well, you got caught red-handed, except it really wasn't you. It wasn't this wasn't yours. So, you have all the social justice issues of that kind of a circumstance. A public defender is going to look at you and say, you were caught with the drugs in your hand, and the police officer tackled you and took the drugs away right then and there. How are you going to defend that?
Right, and the public defender's heard 100 times that somebody ran by and threw it at me.
Exactly.
And to be fair, most criminal defense lawyers have heard some variation on that theme.
Exactly.
Also.
Exactly. But some of the time, it really is true. A private defense attorney who, again, is going to charge anywhere between $200 and $1,000 an hour is going to say, well, let me see if I can find a witness. And somebody like that might go into the neighborhood and discover that across the street was some little old lady who saw the whole thing, saw the real guy with the drugs throw them at you and keep going, and then the police officer tackled you. Well, that's relatively easy. But you just paid anywhere between $10,000 and $50,000 for a lawyer to get there. Did you come out ahead?
Well, it depends. Depends on what neighborhood you wanted to live in 7 years from now. Right?
Exactly. And therein lies the problem. Let's say you are in that circumstance and you are a 18-year-old kid.
And you just don't have the
you don't have
even if you wanted to.
Even if you wanted to, you don't have the resources. You're living in a questionable neighborhood. It's all a difficult circumstance, but your life is just beginning. You don't. If you really fight that, you could end up going to jail for 10 or 20 years. If you figure out a way to make a deal, maybe you can go to college and make something of yourself. But at the other end, hold on, you pleaded guilty to distribution of narcotics.
Yeah, there's certain apartment complexes that wouldn't want you living there. Right. That's hard, because even if you knew that, you might not.
Right.
You might still say, that's fine. I'm happy to not be in jail for a year, versus there's a couple places where I can't live. But it's even worse when it's not actually you.
Exactly. And that occasionally happens too. I have a client who, again, similar circumstance to one of the dozen other cases that I've described. My client has lived in Virginia all of her life, never been to North Carolina. Somebody with the same first and last name. Is this starting to sound familiar?
Right.
Been a guest of the state of North Carolina, apparently multiple times. My client is a perfectly nice lady who has had blue-collar jobs all of her life, always done the right thing, paid her bills, never had so much as a parking ticket. But every time she goes to get a new job, and it doesn't matter whether it is working at an assembly line or working as a cashier at the Dollar General, they'd pull a background check and, hold on, you have been convicted of 72 felonies in North Carolina. She's going, I've never been to North Carolina.
Right.
So now she loses the job, and she goes through some process, and sometimes she's able to get the stuff cleaned off of her credit report or criminal history report. Technically, that's a credit report. Relatively quickly. Sometimes it takes some effort, and it takes a little bit of time. But it comes back to it's still not her. It's not the same. It's not the same first name, middle name, and last name. It's same first name, same last name, but the middle initial doesn't match. The social only can be described as being similar in the fact that they both contain numbers.
Okay.
It's a fabulous case.
And so, and this, if you're a prevailing plaintiff in one of these cases, you're again entitled to actual damages and statutory damages and attorney's fees, just like in the Fair Debt Reporting Act.
It's actually a little bit better than that.
Okay.
There are two categories of fair credit claims. There is negligence, where, similar to a car accident, duty breach causation damages, they have a duty to do reasonable things. They breach that duty. They do it mistakenly, and it causes damages. You're entitled to actual damages plus attorney's fees and costs. That's an okay case because, again, the actual damages can be rather substantial. The other alternative, and this is where things get to be lots of fun for me, is where it is willful. Now, the Supreme Court has defined willful as the circumstance where somebody knew what the right thing was and just simply didn't care. Just didn't care. And in that circumstance, you're entitled to actual damages, attorney's fees and costs, punitive damages. Right. Now, under Virginia law, punitive damages are capped at $350,000. Right. Under federal law, there is no cap. So those are really fun swing for the fences kinds of cases. Absolutely. You want to swing for the fences. One of my friends in, again, Oregon, got a judgment for $18 million. One of my friends in Florida got a judgment for $10 million. The guy in Florida who got a judgment for $10 million promptly retired.
Yeah. I understand that.
His portion of the attorney's fees was enough for him to say, yeah, I can sit back and raise chickens.
Yeah.
But the guy that got $18 million, he's a young fella. He can't retire. I mean, he can't retire at age.
Move to Idaho and retire.
Even if he does, let's say he gets, $5 or $10 million. What's he going to do for the next 50 years?
Right.
So he's looking for the next $18 million
I'm sure.
case.
Well, now he's the $18 million guy. It shouldn't be that hard to get those cases in the door now.
$18 million cases are relatively rare. On the other hand, $100,000 cases, $200,000 cases, $300,000 cases are actually relatively common. And so I make my money on those $300,000 cases.
And then Experian and TransUnion, they know that.
Yeah.
And they use that in their settlement evaluations before you get to the trial process.
Absolutely. And they know what kind of a lawyer I am and how, because they've looked at me and they go, we believe he can get a $100,000 or $200,000 judgment, and so we need to settle for something less than $100,000 or $200,000. But he's dangerous. He can get 100 or 200, so we're not going to try and lowball that badly. On the other hand, I bring my $18 million friend in, and all of a sudden
it's a different kind of case. So as we're wrapping up here, how can people find you?
I do the best I can to make it as easy as possible. The website, KrumbeinLaw.com, Krumb, like boy, EINLAW.com. Phone number, 804-592-0792. That is a Google Voice number, so please make sure the first time that you call that you actually tell me your name because it actually asks for it. You can also text, same number. That number calls my office, my cell phone. During certain hours of the day, I even allow it to call my home. I try not to do that very often. You can email me, jkrumbein@KrumbeinLaw.com. There is a Facebook page There is a Twitter that I want to say is RVA Consumer Law.
We'll figure out what that is. We'll put it in the notes. Yeah.
There is a all right. So there's a Facebook, there's a Twitter, there's a Google Plus. Google Plus is going away, I understand. So you can try and contact me there.
So you're everywhere. And if they just Google Jason Krumbein, they'll find you.
They will not have any difficulty finding me. I do the best I can to make it easy.
Similar middle name.
Well, there may be somebody else with a similar name, but if you Google Jason Krumbein attorney, you're going to find me.
Sure. Well, listen, thank you for coming on. It's been a pleasure. And I hope that we can send some cases your way as a result of this.
I hope that I get the opportunity to help your clients, and I certainly hope that I certainly know that anybody in the Northern Virginia area who has any sort of personal injury claim, whether it's car accident or medical malpractice or anything like that, I'm certainly going to make sure that they get your contact information.
Awesome. Well, thank you very much.
Thank you.